I want to remind everybody we're getting to the time of the session when we get all of our bills from the Senate side, and it moves rather fast. So there are only a few days in which to hear the bills. The committees all compete for time and for members, so stay tuned to our House office, our bulletin board, and we will get the messages out and posted for you in that respect. And so I'll have a subcommittee report from Representative Hardin.
Thank you, Madam Chair. The Environmental Quality Subcommittee of Natural Resource and Environment met on March the 5th and the March the 11th. Heard testimony on Senate Bill 101. On March the 11th, Senate Bill 101 passed out of the subcommittee as passed out of the Senate.
Thank you. And to the committee, I will refer you to Rule Number 7, which states to allow maximum time for consideration, amendments to any measure assigned to the committee should be introduced in the subcommittee to which the chairperson has referred the measure. So I wanted to make sure that the committee was refreshed on that rule. We have Senator Watson with us today and Chairman Ron Stevens, who will be carrying the bill on the House side. Let me get your right mic on. Okay, Senator.
Thank you. Certainly appreciate you hearing this, and we have and I beg the indulgence of the committee, but we have presented this in subcommittee as a hearing, and then subcommittee yesterday with the vote out. And but I do want to take us back to sort of the origins of this. The origins date back almost 2 years when Chatham County, as the local issuing authority relating to the Turner Creek boat ramp, wanted to expand that boat ramp, and they had that opportunity to serve the citizens of Chatham County and our great state. There was a disagreement based on that particular construction relating to a 2-inch pipe that ran along the road, and as you know, this was on Whitmarsh Island area, and almost every road between islands is certainly within 25 feet of the marsh buffer, and some of the roads are within 25 feet of the marsh. So that area is used. It is used appropriately, and in this particular situation, a 2-inch pipe run about 1,000 feet to connect the toilet at that facility was used and was needed, and they applied the Erosion Sedimentation Act, put up the silt screens and so forth, and we're going to, and our attorney Jonathan Hart presented that to the state, and the state felt as if there should be some mitigation relating to that, and that would cost Chatham County taxpayers tens of thousands of dollars. And he just didn't think that was appropriate, so he asked, well, what are you basing this on? This was rules and regulations that had been established by the Department of Natural Resources, and that was related to a memo that had been produced over 10 years ago by a former EPD director, and she based that on the rested vegetation along streams or creeks or rivers in middle and north Georgia, which in my opinion I don't think applied to the salt marsh and the salt water, because the rivers and the creeks in the coastal area, if you'll just imagine the marsh and then the river or the creek out there, and that may be anywhere from a few feet to it can be half a mile. It can be a tremendous difference. So that fed up to the Attorney General and fed back and said, you're right, there is no legislation, there is no law related to this, and that fed to the EPD, and that's when on April 22nd, Earth Day last year, the director, Judd Turner, said that there was no law establishing a 25-foot marsh buffer in the state of Georgia, and that he directed, and he felt that as if there needed to be legislation for that, and that's what we've been working on for almost a year. It has been a collaborative effort. I think I have never worked on a piece of legislation in which we've had so much collaboration. We've included all groups, from the private property owners to the 100 Mile Club to Southern Environmental Law Center. We have just, I think we have We have worked on this to a point that I think where we are now, and I think what we have now is a good bill. We certainly don't have everybody happy on each side, but this is a good bill, and I think that we have narrowly defined it, and I think that we are in the Erosion and Sedimentation Act, and I think that's what we need to remember. I have taken the previous committee back through each individual section. I will not do that this time, though if anyone has any particular questions, or if you'd like for me to do that, Chair Lady, I'll be happy to do that. Or we could let we have speakers can help explain or answer some of the questions that have been raised, and then I could follow up with questions or any particular details if anybody has any.
Why don't we, in the beginning, we'll come back to you for your presentation, but this is the meeting, the full committee meeting, when the legislators and members of this committee interact with our state agencies to try and clarify some of their doubts about the legislation or questions they might have. And if you will just find a place to sit, we'll call you back to answer things specifically, and I'll bring up the panel that I've asked to be available to our committee. These are the people who deal with compliance. They're with EPD. They're with our Coastal Resource Division. These are the boots on the ground, and as it is a key part of a debate on a bill that we hear from the people who work on behalf of the state. So I'm going to ask Spud Woodward, Director of Coastal Resources Division of DNR, Mary Walker, Assistant Director of EPD, and Bert Langley, the Director of Compliance for EPD, to come up. I've asked them to each make a brief presentation of the review of this bill, Senate Bill 101, and then at that point in time, I'll open up to the committee for questions. When it gets to question times, the committee needs to remember there's several members here, so we will go per legislator per question, and I ask that it not be involved in our questions will be questions, not statements. And so let's see, we decided, Spud, if you will begin, I would certainly appreciate it. And let me get you, so the mic is on for you.
Right.
Okay.
Thank you, Madam Chair, and good morning, ladies and gentlemen of the committee. It's my pleasure to be before you today to speak to Senate Bill 101 from the perspective of the Coastal Resources Division. As most of you know, the Coastal Resource Division is responsible for administering the Coastal Marshland Protection Act, which was actually passed by the General Assembly 45 years ago this year. It's been a landmark piece of legislation looked at by a lot of other states with quite a bit of jealousy, and it's helped protect our coastal marshlands from direct alterations such as fill and dredging and such things like that would be harmful. Over the past 45 years, we've learned a lot through scientific inquiry and a lot through experience that we can protect the physical integrity of the marsh, but in order to protect the ecological integrity of it, we certainly have to consider things that happen on the adjacent uplands. And so that's the reason that the Coastal Resource Division and EPD work so closely together under our respective legal authorities to ensure that activities on the upland are considered when appropriate and incorporated in decisions about the marshland. And the decision that was made last April essentially left approximately 2,350 miles of coastal marshland upland interface without the protection of a buffer. And so that's how much area we're talking about now that does not have rested vegetation as defined in the law. So people can literally encroach up to the marsh jurisdiction line unless otherwise prohibited by a state, federal, or local ordinance. And so that's a very important point here, is that that's what's at stake, is that this bill does provide a clear statutory basis for establishing a buffer around coastal marshlands. The exemptions have certainly been subject for concern, and I'm going to let Ms. Walker get into more detail on that. But I can give you my opinion that yes, they're subject of concern, but the Board of Natural Resources will have an opportunity to delve very deeply into those exemptions and to promulgate rules that properly balance the oversight with the expediency and the elimination of regulatory duplicity, which I think all of us would like to see happen. So thank you, Madam Chair and members of the committee.
Thank you. And Mary Walker, please, Assistant Director of EPD.
Good morning. Thanks for having us. Thanks for letting us speak to the bill. I wanted to just give you a little sense of a historical perspective for this bill and why you see it before you. For many years, EPD did apply the buffer provisions of the E&S Act along coastal marsh as measured from the jurisdiction line. Much is provided for in this bill. In April, not because of questions about whether or not this was good policy, but because of questions about our statutory authority, we did revise our policy and went back to measuring from the line of rested vegetation. As you know, we are talking about the Erosion Sedimentation Act, which establishes a 25-foot buffer along all state waters. It also requires that that buffer be measured from the point where vegetation is rested by normal stream flow or wave action. So that word rested, I think some of us have talked about, is a noteworthy word, and really means that the vegetation has been kind of ripped and pulled and moved by the movement of the water. And that word works very well in many parts of the state where water is flowing in North Georgia. In the context of coastal marsh, resting of vegetation is a more challenging concept because you don't have that topography and that flow, that same sort of flow of water. So there are places in coastal marsh where you have some resting, and in those cases we did have a measurable buffer. But there are also large parts of the marsh, as Director Woodward has said, where there isn't a resting, and so there's a kind of a gradual movement of the marsh vegetation into the upland, and in those cases there isn't a buffer. Probably for that reason, since there wasn't a measurable point, EPD started many years ago using the jurisdiction line as the point of demarcation. The problem was over time we experienced a number of challenges. Local issuing authorities along the coast, the counties who carried this out, faced challenges themselves, and they were not comfortable with this, and they began giving citizens sort of different interpretations of the statute. And so if you were a coastal resident, you were being told by your local issuing authority that you didn't have a buffer and being told by EPD that you did. And that was really not an acceptable situation for Georgians. Additionally, we did face a very direct challenge by Chatham County and really decided that was the time that we needed to look at the statute and look at our policy, and we needed to make a change. So as of April of last year, when Director Turner issued our memo, we have gone back to an interpretation that is faithful to the statute, which is along coastal marsh, we measure the buffer from the line of rested vegetation. Since that decision, there's been a lot of concern along the coast because there's great interest in protecting our coastal marshlands. It's simply a question of statutory authority. We've spent a lot of time working with coastal stakeholders, with the coastal delegation, and many drafts of legislation have circulated. This is not an EPD written draft, but this is a draft into which we've had much opportunity for input, and our major concerns have been addressed. At every moment where there has been an addition to this draft that was not in ours, there is a provision for the requirement for adequate erosion control measures to be applied and implemented. So we feel like that is clear direction that these not be broad, gaping holes in the bill, that the exemptions are tailored and are faithful to the Act. So at its core, this addresses our major concern of not being able to have authority for the measurement from the jurisdiction line and would allow us to go back to that policy where the entire marsh is buffered per the JD line.
Thank you. And then our next presenter is Bert Langley. He's Director of Compliance, which is, I think, the bottom line to this bill.
Thank you, Madam Chairman and the committee. That is the bottom line. What my role is to look at how we actually will implement. Do we have something that we can enforce in a consistent and fair manner and is as clear as possible for all the citizens? We've looked at all the provisions in this bill, and to the very large extent it resets things back to where we were before. We were establishing a buffer based on the jurisdiction line. This bill basically does that. There are some provisions in it for exemptions. We've looked at them very carefully. We don't see them as broad exemptions. We see them as relatively narrow exemptions, and they are enforceable. And throughout the bill, no matter what happens, you're required to maintain adequate erosion and sedimentation control. That's the purpose of this act. Control the loss of sediment into the marshes, not anything else. So we think we have a good chance here to get back to an enforceable buffer that will protect the marshes from erosion sedimentation.
Thank you. So at this point in time, if y'all will stay here, I will turn this part of the meeting over to the committee members. I ask that each committee member have a chance to ask a question. So if you have a question, be brief with your question and your response be as brief, but answer the question as you can, because we have several members present today and I want to give every member a chance. Thank you. So I'm seeing the lights, and Brian will help me keep up with it. So my first question is number 9. So say your name and then ask your question.
Thank you very much, Madam Chairman. My name is Representative Pat Gardner from Atlanta, and I've heard from a lot of constituents about this bill. They may not live on the marsh, but they may own property on the marsh. So they're very concerned, primarily about the exceptions. I don't think there's any question in anybody I've talked to that we need a buffer, and we need it to be a statutory buffer. So that part we've been very clearly informed about. What I am confused about are the exceptions, and concerned about the impact of the exceptions. And I guess I was going to ask the sponsor of the bill, but perhaps you can answer better. I mean, what do these exceptions mean in practical terms? What's the impact of these exceptions going to be for your... Maybe you start with the one you think is the most detrimental. I don't know. But anyway, if you could help me respond to my constituents about why this bill is going forward with the exceptions.
The exceptions, as written, provide some fairly narrow situations where the buffer would not apply. Many people we've talked to have been reading them very broadly. The 404 exemption, for example, is a very narrow exemption. It only allows for a permit by rule or variance by rule where the Corps' authorized activity in a buffer through a 404 permit. That virtually can never occur, since the Corps can't authorize activity in the uplands, only in wetlands. So it's only a very specific set of circumstances. And that follows through with most of the exemptions, which...
Is there going to continue to be a conflict between the local jurisdiction, the Corps, and...
So finished with that question, we'll move on to other legislators, but go ahead and answer that.
Not that we see. This should eliminate most, if not all, of the conflicts.
Thank you. We'll get back to you if we can. The next number I have is number 12.
Thank you very much. My name is Mabel Thomas. I represent Atlanta. My question is, there's been a lot of talk about the deepening of the port. In any way, does this legislation affect that issue at all? I've heard some rumors.
Not that I...
Move the mic, so just kind of lean to the mic. Thank you.
Not that I can contemplate in any manner. I'm not.
Okay, thank you.
Thank you. The next question is number 24.
Thank you, Madam Chair. Chuck Williams. Can someone clarify for me the current state of affairs? If we have coastal streams which are flowing enough to result in rested vegetation, do we currently have protection there? It's just in the areas where there's not stream flow adequate to create rested vegetation. Is that the situation or not?
That's where we are today.
Okay.
Yes.
Okay, thank you.
Thank you. Number 25.
Thank you, Madam Chair. I've got a question about two very specific areas of concern. Since April of this past year, when this situation unfolded, we've had my name is Jeff Jones. I represent District 167, which is Glenn, McIntosh, and Long. So I have two coastal counties in my district. So pardon for that. There are two specific situations that concern me. In this year since April of last year, there's been a jelly ball factory built in McIntosh County. That jelly ball factory, for those of you who may not know, I'll explain later. It's an interesting sidebar, but that factory was built.
We do not need examples of that. I will tell you.
Okay, thank you. It was built right to the marsh's edge, and apparently with no restrictions, no hindrances whatsoever from any regulatory agency. So my question is, with this new piece of legislation, will EPD be able to enforce and restrict and limit and control construction of such operations right to the marsh's edge?
Well, this would allow for the requirement of a variance for construction within, within the buffer. So
In this particular situation, this particular factory was built to the edge of the jurisdictional line, and in fact, I think over, and as I understand it, without restriction or without regulatory oversight in terms of its construction.
I'm going to let somebody who's familiar with the project.
I think what you've got is two situations. You've got if there was not rested vegetation in that location, then there was no buffer requirement applied. If that was an armored shoreline with a functional bulkhead or riprap or whatever it was, then there was no bulkhead, no buffer requirement landward of that shoreline stabilization feature. So those are the two things that basically right now exempt you from a buffer requirement. So someone cannot come to, if you had a bluff and a waterway with tidal water flows and rested vegetation, there's a buffer requirement in effect for that. And certainly if they were to try to fill jurisdictional marshlands, then they would be required to have a Coastal Marshland Protection Act permit as well.
So is it your belief that with the enactment of SB 101, that EPD will have the authority to control and regulate such construction going forward?
Well, there will be an opportunity, as Ms. Walker said, for variances to be considered, where there are hardships and various other things, but it will create a legal basis for buffers around the entirety of coastal marshlands.
And this SB 101, you believe, gives you enough teeth to be able to do that?
Between
and protect the marsh?
To Spud's point, if there is an active bulkhead already in place, then it would be considered in the same manner as we would consider it throughout the rest of the state, which is our statewide interpretation is where there is a bulkhead, there is not a buffer on the other side, on the landward side of the bulkhead. That is consistent with how we've done it statewide, and so that would be the case here.
Let me just be sure I'm clear. So you're saying that where there is a bulkhead, there is no 25-foot buffer and would not be a 25-foot buffer to the landward side of that bulkhead?
That's correct.
I think further clarification for you. What is the logic behind that?
The logic goes, this is the Erosion and Sedimentation Control Act. It's designed to control sediment, dirt leaving a project getting into state waterways. A bulkhead is a structure that prevents most of the sediment loss off a piece of property into the waterway. Once a bulkhead is in place, the rest of the state, we then have no rested vegetation, so we can't enforce a buffer. It would be the similar manner here with this bill. Once that bulkhead is in place, the control of sediment at the site is pretty much as good as it's going to get. Then yes, you can build right up to the edge. This doesn't address other impacts that might occur from development. It's only designed to address the erosion and sedimentation part.
Madam Chairman, the purpose of the 25-foot buffer in itself is to provide that screening or that filtering of upland material from flowing into the waterways and into the marsh. If a buffer is below grade, how is that buffer going to stop sedimentation and erosion, not erosion, but chemical flow? Again, the purpose of the 25-foot vegetated buffer is to provide that filter. A bulkhead, I would challenge you, does not provide a filter.
Again, our concern in this act is sediment, not necessarily chemical flow or other material moving off the site. That's not what the E&S Act is designed to address, and it doesn't in any other part of the state.
Madam Chair, not to get too deep into this, but for a shoreline stabilization feature such as a bulkhead or armoring to be functional, it's going to have to be built above grade, or else it would be inundated twice a day by the flood tides. So it's going to have to be built in such a way that it provides a barrier between the movement of water off of the upland into the adjacent waters in the marsh. So if it's built correctly and maintained correctly.
All right, I have number 11.
I'm Debbie Bogner, and I actually live on the West Coast, but I own property in McIntosh County, and that's my
father's side of the family, so I've been going there for 60 years. And my question, as Ms. Walker knows, has been around one section of this bill that gives me some heartburn, and she gave a good explanation out in the hall to try to help me understand it better. But here's my question. The way I understand the bill is that it instructs the department to make rules that would provide for like a variance by rule for projects that have received their Army Corps permit under the 404. And of course, these projects can run the gamut from being just a small dock to industrial operations like we've been talking about. What my concern is that this exemption would not allow EPD to take care of erosion and sediment issues until after it happens. Then you could go in and do cleanup, but you can't prevent it with this exemption. That's my concern.
And you're speaking to the 404?
Yes.
Okay. Well, we do read this as narrower than a total blanket for every project where there's a 404. But very importantly, this is a variance by rule, and so this is not a blanket exemption. Our board will adopt rules that will govern this development that falls within this set of parameters. But we read this narrowly to say where an alteration within the buffer area has been authorized pursuant to the Corps permit. The Corps does not have jurisdiction on Georgia's uplands. The Corps has jurisdiction on waters and wetlands. So a Corps permit would not authorize upland impact. If there is there would be a very narrow set of circumstances where this would be applicable, where a Corps permit would authorize impacts within the buffer. Generally speaking, if it's an upland impact, there will still be a variance required.
We have one other question. If you have a further question, it's all right to ask you further questions. Further variances would be required, but you may not be aware of the need for those variances until after something's happened, is what that's been brought to my attention that I need to be sure to check on.
In truth, though, that's probably not any different than now, right? I mean, at times people should apply for variances and don't, and we receive a complaint and we go out and we deal with it as an enforcement matter. That would be something Bert's group would deal with. This would still require either a variance by rule or a variance depending on the nature of the development, and then we would enforce if one were not there.
And the sediment and erosion acts would go into play then, not as preventative.
In the same manner as everywhere else. Do you want
Well, if someone chooses to do a project without following the rules, yes, but the rules are very carefully in place that they should apply for the variance prior to beginning the project. The Corps permit exemption here is so very narrow, I don't know that I've ever actually seen a circumstance where it would apply. There must be one out there, but it is an exemption for a Corps authorized activity in our buffer, which would mean there'd have to be a separate wetland inside our buffer that would be authorized an impact under the Corps permit. That is a very uncommon set of circumstances.
Well, if it's so uncommon, why do we need this exemption?
This is not our exemption. We did not write this.
And it's a variance by rule. It's not an exemption.
Right. It is a variance by rule, which is another. The restrictions that are placed on variances by rule will be put on by rules from the board, and they will be developed very carefully to, again, tailor this to a narrow set of circumstances.
But if that were not in this bill, then we would still have the buffer protection we need for the coast, for the marsh.
We didn't
put this in there.
Put that in.
Thank you.
I really don't know. We really don't see this as a broad, gaping hole in the bill. We really don't. So I don't know that it is in any way a blow to the bill.
Thank you. So the next question is, number 9.
Thank you, Madam Chairman, for allowing me to follow up. I'm trying to follow how this is going to work. I've heard that you believe that the board could make adequate rules to help you do what you need to do to protect the buffer. So assuming those rules are passed and a local jurisdiction disagrees or an applicant for a variance disagrees with your refusal to grant that variance, then what happens? You get sued, right? And because it's not in the statute, it's only in the rules. No?
Well, the rules have enforceability also. If we have a situation where someone challenges a decision of the director, that falls under the Administrative Procedures Act and goes through the hearing process just like any other activity.
So the rules can't be, I mean, somebody can't sue you that the rule was not appropriate to the law.
They can challenge the director's decision to not issue a variance, for example, and that does go through a hearing just like any other activity we do.
Thank you.
Thank you. Number 25.
Thank you for the opportunity to follow up. My understanding in this whole process with this bill and the other discussions that have occurred since last April was to, first of all, establish a 25-foot buffer, period. And then that being established from the jurisdictional line. Again, I realize the question about rested vegetation, that's kind of why we're here, but we're beyond the rested vegetation issue. So again, my fundamental understanding was establish a 25-foot buffer, and then and only then look at and consider variances within that 25-foot. What I'm hearing here is that 25-foot buffer is a nebulous kind of a thing, and if a bulkhead is in place, there is no 25-foot buffer to the upland side of that bulkhead. Is that what I'm hearing today?
Consistent.
So we are not establishing a 25-foot buffer from the jurisdictional line to the upland side.
With respect to the bulkhead issue, we're establishing a buffer in exactly the same manner as exists statewide, because the bulkhead is treated the same statewide as is being proposed in this legislation.
But with no 25-foot buffer. Is that correct?
There's an exemption where there's a bulkhead in place.
To maybe further clarify that question, so is the 25-foot buffer not needed then, if that's the case? I think it's, so the problem is if you have the bulkhead, then why in the world are we having the debate over the 25-foot buffer? How much does the bulkhead take percentage of the coast, and how much would a 25-foot buffer be in place?
I can answer that, Madam Chair. Over the last 5 years, we have documented through the issuance of revocable licenses around a little over 200 bank stabilization projects. And of those 200 projects, it constituted a little over 8,000 linear feet of impact. So again, I think that's where you've got to put this in perspective. You're talking about 8,000 linear feet where you do not have a buffer requirement on the upland side versus the 2,350 miles of upland marsh interface that's sort of in jeopardy now because it has no protection.
So for lay people, is one this big and the other that big, or help us with a hand demonstration?
I mean, as I suppose the state's chief advocate for the marsh, that's the way I see it.
Verse 2000.
All right, I just want everybody to have the visual that, okay. All right, thank you. My last question is 24.
Thank you, Madam Chair, for coming back to me. My question relates to sort of where we are in the process. Mr. Woodward, you said we've got 2,350 miles of interface right now that's currently unprotected.
Yes, sir.
Basically, if this bill passes now and is signed into law by the governor in a reasonable length of time, can you walk us through what will happen as far as rulemaking and the process, and when we would actually have protections in place for that 2,350 miles that do not exist today?
Yes, sir. According to the language contained in the bill, the board would be required to promulgate rules effective by December 31st of this year. So it's a pretty expedited rulemaking process. And so on January 1 of 2016, you would have, through the clarification of rulemaking, the protection of that 2,350 miles of unprotected marsh upland interface.
Yes.
If this bill is not passed and signed into law?
Then that 2,350 miles will remain unprotected by a buffer.
Thank you. Thank you, ladies and gentlemen. We will now call back up our bill sponsor. Sorry, hold on. We had one more question. If y'all sit for just a second, and that'll be our last question. Yes.
Thank you, Madam Chair. I guess I just want to know, because it fell down to we wouldn't have the protection, but if this bill passed as nothing more than a buffer protection with no exemptions, that would give you what you need to protect the buffer. Is that correct? So that if we passed a bill that says we're going to put the 25-foot buffer in and had no exemptions, and we spent the next few months working on what those exemptions really mean and what we really need, and we did it backwards from the way we're doing it now. Now we're doing exemptions with a buffer. If we did a buffer and then worked on exemptions, that would still give the marsh the protection it needed. Is that correct?
I think if you were to establish a buffer in statute and not provide for exemptions in statute, the board would not have power to grant an exemption from the law by rule. We can specify our administrative procedures, but we couldn't grant an exemption by rule. And so as you pass it, if whatever exemptions need to be in the bill as you pass them.
Thank you. And so thank you again for your time. Really appreciate it. So we call back up our Senator, Ben Watson, and Chair of Economic Development, Ron Stevens. Please keep conversation directed to the chair through the chair. Thank you, Senator. And so this is your chance to answer any questions here and to summarize the bill and state your position.
Yeah, there are just a couple of issues I wanted to. The Corps of Engineers, or the Rule 404, that was put in there to reduce red tape, to reduce having to get 2 permits or more permits and that are already required. There's nothing there trying to slip anything by anybody. I think I take offense to that. I have worked openly with all particular parties, and the issue that, listen, this is upland area. This is the jurisdictional line. To say that you're going to come in and I live on the marsh. To say you're going to come in and take my property, for that, I think I have the access to use to that, and that's what we've tried to outline in a very reasonable fashion. So I will tell you, I've gotten pushed from the right and the left. And the right, I have not, discussed that with you. I haven't tried to throw anybody under the bus, but I will say that, you have people there who feel as if there should be no marsh buffer. And I disagree with that. I think there should be a marsh buffer. But is this a taking of their land? I think they have a case for that. Should they be paying property taxes for this, which was asked to be added onto this bill? I disagree with that, but I think they have a point if you're not going to be able to use that land. Is there a percentage that they should not pay on that? Maybe. Maybe we may be dealing with that in the future. But to come in and take the land there, or not being able to maintain it, or have exemptions for your particular piece of private property that hundreds, or I guess thousands of people come and use and have, I just don't. You've got to have a balance here. We've been working on this for a long time. I feel strongly about having a 25-foot marsh buffer. I think that is the right thing to do. I think our marshes are there to protect. Having said that, as stated, I think there should be exceptions. I think it should be well outlined with exceptions. So many times here in the legislature, we get to the big philosophical point. How much do we put into law? How much do we allow this particular agency to do rules and regulations? We debate that every day, all the time in committee. We certainly could have gotten into much more minutia relating to particular buffers that are established now, that is being established exceptions that are being now. We did not do that. we thought that we narrowly defined, and I think that you can see that EPD agrees with that we have narrowly defined a few exceptions. I think that's appropriate. I think that's the right thing to do, and I would ask your favorable consideration for this bill, and thank you very much.
Thank you. Chairman, do you have anything to add?
Thank you, Madam Chairman. Members of the committee, I also live in the Marsh in Savannah. This bill has been worked on extensively. This bill only pertains to soil and sedimentation. Does not pertain to shoreline protection, not even to the marshland protection. Ladies and gentlemen, this has soil and sedimentation only, and it works for that. The exceptions are placed in there, and just to refresh some of your memory, some of the things that we talked about was, let's give the exemptions to the utilities. Well, imagine, if you will, if you've got a sewer line that blows up, to have to go through the process, call it a roadblock, while the sewer is continuing to blow out into the marsh, to get a permit to come back and fix that with your county. Or even better, I've got a huge power line behind my house which runs for miles right into the marsh. Whenever one day the hurricane's going to hit, and I can't imagine Bryan County, Chatham County, and Effingham County, all three of us, being out while we wait for that permit. This is a very good compromise. I ask you to place the buffer, which is right behind my house, and I'm a landowner, so I consider it a land taking, quite honestly. Today, let's protect the more than 2,000 miles of sedimentation to get into our rivers and our streams, and this bill will do that with very, very limited applications. I'd ask for your favorable support. Do not amend the bill, and please don't send it back to the Senate.
Thank you. Thank you, gentlemen.
Madam Chair, at the correct
Yes.
time, I'd like to make a motion, please.
All right, this is the correct time.
All right, I move that Senate Bill 101 do pass.
Is there a second? Second. All right. At this point, any further questions from committee? All right, I have number 29.
That's me, Madam Chair. I was
Yes.
going to make the motion.
Oh, all right. Thank you. Any other questions? All right. All those in favor signify by saying aye.
Aye.
Those opposed, nay. Nay. All right. The ayes clearly have it. Gentlemen, you have your bill. Now you get to join into the House jump rope exercise. You first need to go up to the rules with your bill, and I'm sure Chairman Stevens will help you through that process. Thank you. Thank you, committee. Be on the lookout for notices. We'll try and keep you abreast. Thank you.